Hi, everyone. Thanks for joining us today. Just kind of our quick standard disclaimer. This presentation is for educational purposes only. It's not legal advice and doesn't create an attorney-client relationship. If you're already one of our clients, you can reach out to us with questions. And if you're not a client, but you're interested in becoming one, we'll have some information at the end on contacting us. Also, this is a pretty complex issue, as you probably already know, but we'll get into some details on that today. We're providing an overview really just to try to help you in the employment space. We're not really through a webinar in a position to answer specific questions. The rules are truly so different, as you'll see. This is just more or less to get you on point and even get you thinking about, I don't even know what I don't know necessarily if you're having issues in this space. Also, so that you can keep on with your day, we'll try to get things moving and keep things moving with this discussion. So marijuana / cannabis, what are some overall considerations? So you'll see I use the term cannabis here. The reason why is because you see the terms under the law, both terms are used. Technically, cannabis is considered the broad term for the entire plant itself, the biological plant. Cannabis, that's the plant. But marijuana refers to the parts of the cannabis plant, so that could be flowers or leaves that contain the psychoactive and intoxicating molecule tetrahydrocannabinol, THC. You'll hear me talk about THC today, and if you do, just understand that that is the intoxicating substance or molecule that comes out of the marijuana plant or cannabis plant. State laws vary, and you're going to see the terms within state laws, either cannabis or marijuana, used extensively. Federal law generally uses the term marijuana, so it's best to be familiar with hearing both the term marijuana and cannabis. This is a big topic, and there's a lot of ongoing concerns just even outside of the employment space. I mean, there are political concerns on this topic. Many people across the full political spectrum from left to right strongly support legalization of cannabis. Many others strongly oppose legalization for a variety of reasons. Some have ethical objections. They're thinking, should another intoxicant be made available legally for people to consume? There could be religious reasons that people might oppose marijuana. Will legally permitting use of a drug diminish human spirituality? That could be a religious exception to it. There are moral concerns. Will more availability of a new intoxicant negatively affect society overall? Those are just kind of some of the questions that come out of people's minds when they think about this subject. There's also kind of a patchwork of laws right now. So federally, there's the Controlled Substances Act. We're going to talk about that in a moment. State laws, there are some or many states actually that are touching on this subject, both in the medical space and in the employment space. We're going to talk about both because the medical space definitely can affect the employment space with marijuana. And actually, we say, legalization of marijuana, I would actually describe it as decriminalization by the states. I wouldn't say necessarily that the states are legalizing. I would more say accurately that they're decriminalizing. Decriminalizing means that the state law enforcement, so think of local police, sheriffs, state police, and also the courts, they won't criminally prosecute individuals for cultivation, possession, use, and distribution of marijuana in certain circumstances. We'll say legalized today or legal states, but really think of it as a decriminalization issue at the state level, meaning the courts and the police are not going after people under certain circumstances. Even localities, cities or counties get into the mix on the legal side of things when it comes to marijuana. There can be zoning rules on where retail shops can be located or medical shops, and also where items can be grown or manufactured. At the local level, there can also be something called a labor peace agreement. That has to do with unionization. That goes to organizing of cannabis industry staff workers. So there's a lot of different factors that come into play on the legal side with this. At the community level, people have concerns as well. People are worried about crime. They're worried about people driving under the influence. But interestingly, as a side note, and we'll address this, there's no broadly used test right now to see if someone is impaired. That includes your employee. We'll talk about that in a little bit, but that's one of the concerns in the communities is we don't want people necessarily being impaired. They're driving, whether that be alcohol, whether it be marijuana, whatever. That's a concern that comes through. So just this is a way of saying there are a lot of factors in play with this subject. Let's start at the big, broad federal level with marijuana. It is illegal, still illegal under federal law, despite what you might see in your state or read about. Marijuana is illegal under federal law. The first time this was addressed was back in 1937 with the Marijuana Tax Act. It made cannabis illegal in the US. Note on the screen the spelling of marijuana. It uses an H, not a J. That is something that you might see, in fact, in New York State right now. There are some parts of laws addressing this topic that still use marijuana with an H. Some use marijuana with a J, and some use or address cannabis. So that's just another idea to get you in the mind of how long this issue's been around and how there's even been somewhat of an evolution with the term that we're discussing. A bigger law that now is in place, however, at the federal level is the Controlled Substances Act, the CSA, passed in 1970. Under that law, cannabis was codified as an illegal substance at the highest level. It was classified as a Schedule I drug. We're going to talk about some of the scheduling, but marijuana is at the highest level of illegality federally, Schedule I. Under federal law, Schedule I drugs are defined as those with no currently accepted medical use and a high potential for abuse. So that's the same level as LSD and heroin. So marijuana federally is still very, very highly considered illegal. A lot of people will ask though, hey, we hear a lot in the news about fentanyl. There's a fentanyl crisis in this country. Why are dangerous pain medications like fentanyl considered more legal than a plant-based substance such as marijuana? Why is that higher on a higher schedule than fentanyl? Well, the reason is classification by the federal government, particularly the Food and Drug Administration, the FDA. So marijuana is a Schedule I drug, as we discussed. Fentanyl is a Schedule II controlled substance. While it is highly addictive and it is abused, definitely, it's also recognized as a medicine with a legitimate medical uses by the FDA. Hence, that's why it's on Schedule II. In contrast, marijuana, Schedule I, not recognized as a prescription medicine by the federal FDA at this time. There was some talk during the last federal administration a couple of years back about rescheduling cannabis / marijuana, moving it from Schedule I down to Schedule III. So at the next level down from fentanyl, the Department of Health and Human Services recommended that the DEA move marijuana from Schedule I to Schedule III on the Controlled Substances Act side of things. Some of the Schedule III drugs that people have heard of might be like codeine, ketamine, testosterone, anabolic steroids. So they have medical uses, lower risk of abuse. They need to be prescribed, but they are not completely out of the medical realm like a Schedule I drug would be. Right now, it's unlikely that rescheduling of cannabis is going to be a priority of the current federal administration. That's just not something that they're really that worried about. But even if there is a rescheduling at the federal level from Schedule I down to Schedule III, that's not going to necessarily resolve the discrepancy between state and federal marijuana laws. So now we're going to talk about some of the state stuff with marijuana. There's a lot of different approaches out there with the states, how they're approaching this topic, whether they're going to legalize / decriminalize, whether they're going to allow medical, recreational, both. What are they going to do? And I kind of want to give you an overview because it's almost certain that your state where you operate, or states, if you're a multi-state employer, you're going to have rules that are going to apply at the state level outside of even the federal stuff. So this is something worth kind of looking at. There are a lot of different approaches to marijuana at the state level. Some states only look at medical. 40 plus states and the District of Columbia address under their laws some form of medical marijuana / medical cannabis use. That is a huge area. Again, it's the majority of the states, with DC thrown in, not as a state, but as a territory of the US, it's 40 plus that look at medical. Medical and recreational use for adults is another approach by different states. That's 20 plus states and the District of Columbia allow medical and recreational for adults. The next area is sort of interesting. We're going to talk about it a little bit because this absolutely shows up in questions we receive from employers regarding some of the other topics we'll discuss regarding testing and things like that. But this is an interesting area. So some states have a regulatory scheme for cannabinoid products and federally legalized hemp or hemp-derived products. So what does all that mean? What is this hemp talk that we're looking at? So in 2018, the federal Farm Bill created a loophole that many feel authorizes creating concentrated hemp products that are not technically from marijuana, and that allows them to be legal. Hemp products on the market may be classified differently, as the hemp plant is considered botanically different than the marijuana plant. It's not the same under federal law. Hemp doesn't contain as much THC, the intoxicating substance that we talked about, as a marijuana plant would, so they're considered different. It's separate. I mean, hemp has been used and is used to make rope, fabric, paper, other non-intoxicating uses. So hemp can legally be grown under the Farm Bill. Yes, there is some THC in it. Again, the intoxicating agent that you find in marijuana too, but it's super low THC in hemp. However, with that Farm Bill in 2018, hemp product production expanded, and a lot of people saw, hey, we can use chemistry, we can use science to extract THC from the hemp plant and then super concentrate it into a product that does produce intoxication. The argument is that, hey, this is just a hemp plant, that's legal federally, we can take stuff out of it, we can turn it into an intoxicant, it's not a marijuana plant. So that's where employers in states where there is not marijuana have run into problems because of these other products that their employees may be using. The term that we see sometimes is like gas station hemp products, so like a vape or an edible that contains very concentrated THC. That's either like delta 9 molecule or delta 8 molecule that's pulled from hemp plants, not a marijuana plant. So they take the legal hemp, use a chemical process, extract the very small amounts of THC, but then concentrate them. So that's a workaround that some of the states where marijuana is not legal, they've seen issues where, okay, now we've got this hemp-based stuff, it's not regulated, it's federally legal, it's in gas stations, my employees are smoking or eating it, what do I do? That's one of the issues that can come up. It can absolutely lead to a positive test for cannabis. We bring this up just because it's something to keep in mind. It's just kind of a weird field, even if you're not in a legal state. This is something that you could see in your workplace. The last bullet point here is limited use of products containing lower levels of THC. So some states that have allowed medical marijuana, they're super restrictive with it. They permit only very, very low strength THC products for medical patients and very limited delivery methods, but we'll talk a little bit more about that in just a moment. So as we kind of have alluded to, and as you've heard, there's a conflict between the federal and state laws regarding the topic of marijuana. So states have decriminalized or quote unquote legalized marijuana in some forms, medical, recreational, hemp-based. It just depends on how the state legislature has approached it. Federally, cannabis is a Schedule I drug, no recognized medical use, high probability of abuse. So there's an ongoing tension for employers to be aware of and deal with in their workplaces with the difference between federal law and state law. The states are basically plowing ahead with their cannabis rules. The federal government could technically enforce anti-drug rules relating to marijuana against the states. It absolutely could swoop in. The U.S. Department of Justice, the Attorney General, could absolutely swoop in on states that are allowing marijuana production, sales, things like that. The problem, however, is that it is absolutely not a priority during the current federal administration and the last federal administration. It's not a priority what the states are doing with marijuana. There's no political will or resources to crack down in that space at this time. Both medical and recreational marijuana are popular. They're very popularly supported by the general public Again, as I mentioned earlier, from the far left to the far right, a lot of people support medical and or recreational marijuana. They don't want a full prohibition on marijuana, so the feds aren't really taking action on this topic. Here's a hugely important thing to keep in mind with your business, with your employees, and that's drug testing and employment. Just as kind of a preliminary thing to think about, drug testing is mandatory for some jobs, required by law. For example, United States Department of Transportation, or US DOT, has rules that require testing under federal law for interstate motor carriers, aviation, railroad, pipeline, commercial marine employees. If you're a US DOT covered entity, there is a very strong chance that you're going to be required by law to test employees both before employment and during employment at specific time under the US DOT rules. The purpose of these rules is to help prevent accidents and injuries from the misuse of alcohol, because the US DOT rules also cover alcohol, and controlled substances such as marijuana by employees who are performing safety sensitive functions in their covered industries. Marijuana is definitely one of the substances that's tested for under the US DOT rules. DOT required testing, if you're in one of those industries, will most likely supersede any state law that you have regarding marijuana, or any state law that you have regarding medical marijuana, recreational or medical. Again, under federal law, which is the US DOT rules, they're federal laws. Under federal law, marijuana is a federally listed Schedule I controlled substance. So that's a huge issue of concern. If you're a federal contractor, your contract may require drug testing, including for marijuana, and excluding any of your employees from working on that US government contract if they are testing positive for marijuana. State laws, there could be state laws that require drug testing for some positions. Examples would be law enforcement, corrections, maybe daycare workers, maybe certain healthcare workers. In your industry, you could be subject to mandatory testing at either the federal or state level, depending on the law. So what do you do as an employer if you're either required to drug test or you want to drug test? Well, you want to have a written drug testing policy and you want to follow it. That's the best way to stay consistent. Then you know the rules, your employees or your applicants know the rules. A drug testing policy is going to provide everything that someone needs to know about your test. Also, as an employer, you want to enforce the policy evenly to avoid discrimination claims, retaliation claims. It can't be all over the map. It has to be a consistent process under the policy. It's a very good idea if you have a policy that you make sure it complies with state law. Many states have some sort of drug testing rules. Some states are super strict with drug testing rules. Think of Arizona, Iowa, Minnesota, North Carolina. They have very strict drug testing rules. You want to follow the rules if you're doing pre-employment testing, such as who can be tested or who must be tested. Again, that could be under federal or state law, depending on the type of industry you're in. What substances are tested for? When can the testing occur? How is the testing done? Is it hair? Is it saliva, blood, urine, etc.? Where is the collection and analysis of the sample performed? Those are all rules that are very important to be aware of if you're conducting testing, either voluntarily or because you're required to. Reasonable suspicion testing, we get a lot of questions on this. That's something that's used when an employee appears to be impaired at work. In your drug testing policy, if you're going to be doing reasonable suspicion testing, you want to have clear written criteria. What are some factors to consider? Maybe an employee's appearance, their speech, demeanor, their behavior, how they smell, things like that. Also, if you're doing reasonable suspicion testing, identify the individuals in your organization who are allowed to make that reasonable suspicion assessment. Maybe it's your supervisors, maybe it's your managers, maybe both. Whoever it is, if you're going to be doing reasonable suspicion testing, be sure that those individuals have something to go by, some training, some rules of their own to follow, so they know what to do when observing and documenting someone in reasonable suspicion situations. We touched on this. We want to get a little more in depth now. Medical marijuana under state laws. The theme of this presentation, or one of the themes, could be the state rules are going to vary. That's just something to keep in mind. So regardless of which state or states you operate in, the rules are going to vary. Generally, though, as an overview, with medical marijuana, a medical practitioner has to provide the patient / employee with a certificate, in some established form. So the state might say, hey, if you're going to be a medical marijuana patient, you have to see a medical provider and they have to provide you with this standardized form. Also, a lot of times, somebody who's a medical marijuana patient / card holder, under the state's rules, they have to register with the state to become legally considered a medical marijuana card holder. That definitely comes into play in employment situations because some states, as we'll discuss, have protections written into their law specifically addressing employees who are medical marijuana card holders. For some background, what are some of the conditions that can qualify somebody to receive medical marijuana status? It's going to be different in each state. A lot of the very common conditions would be ALS, maybe MS, cancer, glaucoma, HIV, chronic pain, seizure disorder, epilepsy. Those are some very common ones across a number of states where you see as qualifying medical conditions for someone to get a state registered medical marijuana card. Some other states are a little more permissive. They might allow conditions such as autism, PTSD, sleep apnea, inflammatory bowel syndrome, Alzheimer's, Tourette's, anxiety, things like that. Those could be covered in your state, but it's all on a state-by-state basis. Some of the rules also talk about how much marijuana or how much product can a medical marijuana patient lawfully possess. I mean, it depends. In Minnesota, for example, a medical marijuana patient can have up to 2 pounds, yes, pounds of dried marijuana flower, but they have to keep it at home. They can't bring it to work, for example. There's going to be rules on how medical marijuana can be consumed. Some states are very restrictive, as we kind of alluded to. In Iowa, you can only use CBD to treat a debilitating medical condition. Now, CBD is also a byproduct of a cannabis plant. CBD is a cannabidiol substance. It's a naturally occurring compound found in the cannabis plant. It's different than THC. It does not produce intoxication or psychoactive effects like THC does. CBD has effects on people, but you're not high, you're not intoxicated like you would be from THC. So Iowa is super restrictive. Texas does allow THC, but only low dose. So that means less than 1% concentration of THC in the material that the person is consuming. And also it allows, limits what can be consumed, that you can't smoke. You might have to use an edible, a tincture, something like that. Some states do allow smoking of the cannabis flower for medical marijuana, some don't. There can be state reciprocity if you've got multi-state employers and somebody's a card holder. There can be a reciprocity between one state or another for a card. So states that do look at reciprocity are Arizona, California, Colorado, Illinois, Massachusetts, Michigan, Nevada, Oregon, Vermont, Washington. Those are some examples of places where an employee of yours could have a card from one state and it has to be honored in another state. Just something to keep in mind. There can be workplace protections in the law for medical marijuana users. In many places, an employer can't refuse employment or otherwise discriminate a medical marijuana card holder just because they have a card. So if you're interviewing somebody, they disclose, outside of any testing or anything, they just disclose that they're a medical marijuana card holder. Just because they say that, in some states, that is protected. You can't take action against them solely based on cardholder status. We'll talk a little bit more about that. Generally speaking, this is kind of important. Possession, use, and impairment at work are not allowed. But of course, we've got to make things difficult. There's always going to be some exceptions to this general rule. Some states do go easier on the possession at work rules. For example, Arkansas, an employee could have up to 2.5 ounces of medical marijuana at work. but they cannot be intoxicated on the job. So they can have it, but they can't use it or be impaired on the job in Arkansas. However, different than Arkansas, North Dakota, and Oklahoma, for example, employees can't possess any medical marijuana at work. Check your state rules. That's the kind of the bottom line here. But generally speaking, possession, use, and impairment are not allowed, but there's a little bit of wiggle room on possession depending on where you're located. Just to give you kind of a contrast of different things, we're going to talk about 2 different states and how they approach medical marijuana with a couple of just quick case studies here. There was a court case out of Arizona that said an employer can't automatically terminate a medical marijuana card holder with a positive drug test where no impairment was shown. So the person was tested by the employer under the Arizona's very strict drug testing laws. The person tested positive, but an adverse employment action couldn't be taken against them because they were not impaired. There was no record of impairment. Just because they were testing positive didn't mean they were impaired at work. But an Arizona employee is not protected if the employer would lose a financial or licensing benefit under federal law or regulations due to a positive drug test. So that goes back to what we spoke about before. If you're an employer in Arizona, you're a federal contractor, your federal contract prohibits people who test positive for marijuana, or you're an employer covered by the federal U.S. Department of Transportation rules. In Arizona, if you're one of those employers and you have an employee who tests positive, that person is not protected. You can't have somebody who's going to be violating a federal contract that's going to negatively affect your business. But let's contrast that with Colorado. Colorado takes a slightly different approach than Arizona. There was a case where termination was allowed for an employee who tested positive for marijuana, even though the employee was a medical marijuana card holder, he used outside of work, so not impaired at work, and he had a legitimate debilitating medical condition. What the court in Colorado reasoned was that consumption of marijuana is still illegal under federal law, so that employee was not protected by Colorado's legal off-duty conduct law. Some states have laws that protect something an employee does out of work. They generally started to protect employees who smoke tobacco outside of work or who drank alcohol outside of work, but now they've been expanded to cover other things like gambling, marijuana, things along those lines. That's how they're interpreted. But in Colorado, the legal off-duty conduct law did not protect this employee because the court interpreted legal off-duty conduct applied to both state and federal laws. So marijuana is still illegal under federal law. This person did not keep their job because of that application of the law looping in federal laws as to whether or not something was legal. So note also that some states expressly allow employers to provide no additional workplace protections for medical marijuana users, whether in hiring or continued employment. So if you're in Georgia, Iowa, Mississippi, and Ohio, if there's somebody in your state who's a medical marijuana card holder, they do not have employment protections under the medical marijuana law in those states, even though they're following the state law and limit their use to off-duty hours. If they have a positive test, again, Georgia, Iowa, Mississippi, Ohio, they may not be protected in their job. Some states do, of course, to make things more interesting, have employment protections, thinking now of California and Minnesota. A person can't be denied employment or fired only because of a positive marijuana test. So just the positive drug test on its own in California or Minnesota can't get you fired, but other exceptions could apply as previously discussed. So it could be a federal contract rule. You could be a federal US DOT covered employer. You could work in a safety sensitive job. Under those conditions in California or Minnesota, you may be able to get rid of somebody for a positive test, but otherwise you've got to know what the law says about when you can do something. In the HR department at your company, one of the big issues that's always going to come up is disability. And that is no different when you're dealing with a topic like marijuana, whether that be recreational use or medical use off duty. You're still going to be covered under the Americans with Disabilities Act if you've got 15 or more employees. the ADA applies. The ADA requires employers to provide a reasonable accommodation to a qualified individual with a disability to allow the individual to keep working, unless accommodation would create an undue hardship for the employer. There could also, just as a side note, be a state equivalent to the ADA, but right now we're just focusing on the federal ADA. So with the federal ADA, marijuana use is not explicitly protected. Again, ADA is a federal law. Marijuana is a federally illegal drug. It's a Schedule I drug, the most illegal drug. So not protected. But state laws are coming into play, as I noted. So if you're in Maine, Connecticut, Rhode Island, for example, some of those states have statutory language prohibiting discrimination against applicants or employees based on their status as a qualified medical marijuana user, and they use marijuana outside of work. So even if the ADA doesn't cover someone or protect them, a state law might, depending on where you're operating. A lot of legislatures across the country are looking at marijuana statutes. They're looking at medical marijuana. They're looking at recreational. So they are trying to address this process as it evolves. A lot of courts in different states across the country, again, state courts, are interpreting disability claims to require an employer to go through the interactive process before disciplining or discharging an employee who has used medical marijuana outside of work. So there could be a state law that's similar to the ADA that's in play. If you've got a medical marijuana patient, they've got a positive test, you've got to look at all these different layers before you take an adverse action. You want to kind of tread lightly and make sure that you're checking in with us, if you're one of our clients, to see what the lay of the land is based on the size of your business. What is your industry? What kind of work is the person doing? Which state or states are you in? Those are the kinds of issues you really need to look at with a medical marijuana person. And interestingly, even though the ADA doesn't protect medical marijuana use, the federal ADA, again, it may require an employer to accommodate the underlying medical condition of the employee. So under the federal ADA, again, medical marijuana is not protected, but the person's condition that they're subject to may be protected by the ADA, and there may need to be an accommodation for that person. It just might not be medical marijuana under federal law. Also note that an employee who's in recovery from addiction is protected by the federal ADA, but again, use of medical marijuana is probably not going to be protected under the federal ADA, but may be protected under state law. You also, again, we're going to mention it again just to keep this in mind. You've got the federal ADA, you've got state medical marijuana laws and disability accommodation laws. You also have the state legal off-duty conduct laws. That's another area you want to be aware of. Some states have those laws, as we've discussed, where you've got to not necessarily be able to take a adverse action against somebody if they did something that's legal off-duty. A medical marijuana cardholder's positive test for cannabis may need to be treated as a request for reasonable accommodation by law, depending on which states you're in. So even if the use is not protected, you've still got to get into the reasonable accommodation process by law. It just depends. This is a question we see from time to time. Workers' compensation, how does that work with medical marijuana? As you'll recall, workers' compensation rules are each state has their own rules. It's governed by state law, so it's outside the federal system. But how does it work with work comp and somebody who is a medical marijuana card holder or becomes one, they're injured? How does that come into play? So the question is, do employers have to reimburse employees for the cost of their medical marijuana treatments? I mean, it depends. There are a couple of cases I'll just talk about real quick here that have similar fact patterns but different results because of the state law. New Jersey has concluded that employers have an obligation to reimburse their employees for medical marijuana under the workers' compensation laws of the state. Out there, a guy got hurt at work. He wanted to use medical marijuana. The employer didn't want to have to cover that, but the court said, yeah, you have to under our state laws. Contrast that, though, with Maine. They're saying, kind of like what we have discussed today, there's a conflict between the substance of marijuana being very illegal at the federal level and the state's more permissive rules stating that it is decriminalized or is legal in that particular state. In Maine, the court said because there's a conflict of the laws and federal law says that marijuana is still illegal, reimbursement costs do not need to be provided for a work comp person under state law. So I throw that out there as an example of another area where there can be complexity for employers. This again from the work comp side, it's going to depend on what your state laws say. That's what you need to look at. So with all of this information in mind that we've been discussing for you as the employer, what are some practical considerations? What do you need to be thinking about in your business with your employees as you're addressing this issue in the workplace? Whether or not marijuana is legal in your state, a question is, are you going to test for it? If you do drug test, either again voluntarily as a company policy you decide we're going to do this, or because you're required to drug test based on your industry, or because you're a federal contractor or some other reasons under law, you've got to know, number one, which laws apply to you and then how they apply to you. Again, there are federal laws requiring drug testing, transportation, federal contracts, national security jobs. Those types of things are going to require drug testing of employees, including for marijuana under federal law. There are a ton of state laws governing drug testing. You might need to test for some specific jobs under state laws. We mentioned, again, law enforcement, could be healthcare, could be something like that. Some states have no protections for an employee with a positive marijuana test, as we've discussed. Others would require looking at the employee's medical marijuana card holder status before you can take action. And some states where both medical and recreational marijuana are legal, they prohibit employers from taking an adverse action solely based on a positive test. It has to be for another reason. So it's just really kind of a patchwork of what employers need to be aware of. I want to touch again, we just mentioned it, but it's important. You want to see if your state has a legal off-duty conduct law. If somebody has used marijuana off duty, you're not sure, what can you do if you get a positive test with somebody? The rules for how drug testing can be done for marijuana are all over the map as well. Just in the last year, a couple of new states have voted to allow recreational marijuana. Those would be Missouri and Ohio. Their rules are going to be different than, say, California. California is going to be a little more employee friendly. They've recently added employment protections, as we touched on earlier, where you can't get rid of somebody in California only because of a positive test unless there's some other factor based on job, federal industry, things like that you have to consider. Your workplace policy. If you do test, you want to make sure you've got a drug policy. A lot of employers, because of all these complexities, unless they're required to do so, a lot of them have just stopped testing people for cannabis at all. They've removed it from the drug screening panel because they don't care. They're going to treat it like alcohol now. That just means you can't have it at work, you can't use it at work, you can't be impaired at work, but they're going to treat it like somebody walking in with a six-pack. Can't do that, but if you drank a six-pack over the weekend, the bosses don't care. They don't want to test you. Same as if somebody ingested marijuana in some form over the weekend. You come to work Monday, you're not intoxicated by marijuana. They don't care. They don't want to test for it. If you have a policy, make sure it's clearly written. It's got to be consistently enforced. It's important, again, if you're doing the reasonable suspicion testing like we discussed, there could be some state rules on specifically what constitutes reasonable suspicion. It could be the employee's speech, their appearance, their conduct, their demeanor, their smell. If you're going to conduct reasonable suspicion testing, have it in your policy and then train your supervisors and managers or whoever you designate for reasonable suspicion investigations. You got to make sure that they are on top of those rules. What is impairment? This is a humongous question that comes up not just in the employment space as we're discussing today, but it comes up in the criminal law space as well for drivers and things like that. If you're an employer and you're doing post-accident drug testing, that's part of your policy. You test for reasonable suspicion, you test post-accident. there could be some rules in your state depending on how the testing can be done and what has to be tested for. For example, California is in the process of getting very specific for marijuana testing on metabolites, which are substances that can show up after somebody has consumed marijuana. The metabolites are in all kinds of different forms. So what metabolites are you testing for? Just because somebody tests positive, does that mean that they were impaired? Marijuana can stay in somebody's system for days and or weeks. Somebody could have eaten some low strength marijuana edible several days before they're tested, clearly not be intoxicated, but it could still show up in their system. In California, as I said, they're in the process of getting more specific with their testing and looking at, okay, which metabolites did your test? Did it, we don't care if it caught everything. What did it catch? So did it catch the intoxicating ones? Did it catch the non-intoxicating metabolites? Did it catch both? Do you not know which metabolites? It's going to get down to that level where impairment is going to be very, very strictly controlled, and just a broad test that catches, yeah, they used it, but it doesn't say anything about impairment, or we're not sure about impairment. That's going to be an issue going forward. However, for employers, there is kind of a workaround for this. If you've got an employee that had a positive drug test for marijuana, and then you coupled that with reasonable suspicion, meaning your trained manager observed the employee and noted any indicators of intoxication or being under the influence, that positive test coupled with that report by the trained individual spotting those indicators of intoxication could help you as an employer be in a safer space if you want to take an adverse action. It doesn't really matter overall if we take kind of a half step back what substance somebody is on. If you're doing reasonable suspicion testing, it could be alcohol, could be pain pills, could be marijuana. If you've got your trained manager or supervisor and they see a particular behavior by an employee that shows, hey, that person might be messed up, and then that's paired with a test, either based on reasonable suspicion or post-accident, then those manager observed and documented notes along with the positive test could help confirm the employer's suspicion that somebody was messed up at work. That's going to help you as an employer if you do decide to take an adverse action. What about zero tolerance? That's a question we get pretty frequently. If you do want a zero tolerance policy, be aware of whether medical marijuana must be accommodated in your state. That could be something where a zero tolerance policy may not fly depending on how your state law is written. I mean, you'd sort of look at it in the same way that you'd look at if somebody broke their leg or they had surgery, they're coming back to work, they're still taking some pain medication, for example, prescribed by a physician. You want to see that they can safely do their job. That's kind of the main factor that you want to look at. If you do have some impairment language in your policies, including zero tolerance, you also need to include language about reasonable accommodation. Even if marijuana use does not have to be accommodated under the federal ADA, it may have to be accommodated under state law, or under federal law, the underlying condition may need to be accommodated. So again, this is a highly complex subject, but the good news is that there are ways to get information to solve some of these puzzles. And we are the good news. How can we help you? Ask us. If you're one of our clients, shoot us a question. We stay on top of the changes with workplace marijuana laws. We're monitoring it. We're very aware of it. If you receive our weekly newsletter, make sure you're reading it. If you're a subscriber, check it out every Tuesday. If you're interested in subscribing, send us a message at info@myHRcounsel.com. We frequently are addressing a wide variety of workplace topics, but that certainly includes marijuana rules as they apply to employers. We can also advise you on the best way to handle sticky marijuana employment issues. This area is complex, as you've heard. It's changing. States are changing their rules, evolving their rules, whether you're going to drug test, how you're going to test. What if my employee has a medical marijuana card? What are the laws in my state? We can help with all of it. You want to avoid those costly workplace marijuana mistakes, so reach out to myHRcounsel if you have any questions, and I think Dan has some closing remarks.
Once again, thank you all for attending today. The material covered by Michael gave us a lot to consider regarding these complex marijuana laws around the country. If you have any questions on the material that was covered, once again, please open up a ticket in our portal. This way you can connect with one of our attorneys within 2 hours or less and get a specific legally backed answer to your scenario. And if you're not a client, please email us at info@myHRcounsel.com. We'd love to schedule a demo with you. And thanks again. We hope you have a great rest of the day, and we hope to see you on another one of our webinars again in the future.